Thanks everybody for coming, especially on a cold Saturday morning in December when there's football and Christmas shopping and lots of other things that are more fun to do, but we hopefully will give you some good information today. Maybe you'll learn something. We are starting out with a pretty, honestly, depressing topic, but we'll try to keep it light, and this is information that most people do need to know. So we're going to talk a little bit about estate planning, and before we do that, thank you for being teachers. Law school was hard, but I think being a teacher would be way harder. I don't know how you do it. I have a ton of respect for teachers. Also, congrats on upcoming retirement for a lot of you. Retirement is a great kind of like milestone to think about doing some estate planning, because usually by retirement, your family situation is settled, your assets are pretty much in place, and it's just a good time to think about that and get some plans in place. So we're going to talk about some of that today. So we're going to talk about what is estate planning. So estate planning, the kind of dry answer, is planning for the process of accumulating your assets, managing your assets, transferring them during your lifetime if you're incapacitated, or after you pass away. And you want to keep your objectives in mind. So tax issues, legal issues, making sure that what you want to have happen happens. So there's a lot of goals of that. Obviously, you want to transfer your assets to who you want to get them at your death. You don't want Uncle Sam getting them. You don't want people you don't like getting them. So that's probably number one goal when somebody comes in my office. How do I get my stuff to who I want it to go to? Obviously, nobody wants to pay taxes. I rarely have a client say, or no, not rarely, never have I had a client say, help me pay more taxes. We want to avoid taxes to the biggest extent possible. Good news is we're in a pretty tax-friendly environment here in Georgia as far as estates go, and the feds are taking it pretty easy on us now too. We'll talk about that in a minute. Obviously, you don't want to pay a lot of money to have any of this happen. You don't want to pay a lot of money to lawyers, unfortunately. You do not want to pay a lot of money to accountants, to courts, anything like that. So we want to make this whole process of getting stuff from point A to point B as cheap and easy as it can be. Another goal, you want to make sure money's available for things like funeral expenses, taxes, medical expenses, things that pop up after you pass away or kind of at the end of your life, that it's not fun for family members when they're grieving to have to cough up a bunch of money and hope they get paid back for mom's funeral or something like that. So that's a goal too. You also want to make sure your health care wishes are followed. And you want to make sure that somebody, if you become incapacitated, somebody can legally act for you. So paying your bills, keeping stuff going if you're ever unable to do that yourself. So we're going to talk about some documents that pretty much everybody needs. These are the big three in Georgia. Everybody needs 3 documents. I say everybody. There might be a few exceptions, but pretty much over the age of 18, most people need these. So the first one's a will. Obviously, everybody knows what a will does. It tells where your assets go when you pass away. Some are simple, some are complex. Wills always name executors. So that's the person that's actually in charge of getting these assets from point A to point B. If you have minor children, which most people in here are near retirement age, probably not a ton of minor children. If you do, we'll name guardians for them. Wills also sometimes establish trusts. So trusts are just a tool where somebody holds assets for someone else as a beneficiary. And those are very common in the case of minors. Obviously, if somebody passes away, you don't want the minor kids getting their hands on a bunch of assets. So we set up trusts for those. The other 2 documents are power of attorney and healthcare directive. For a lot of people, the power of attorney is actually the most important of the 3 documents. Everybody thinks the will's the most important, and sometimes it is. A power of attorney, I just can't emphasize how critically important it can be. It gives the power to someone else to handle your stuff while you're alive, and it's designed for incapacitation. And a power of attorney always ends upon death. So a couple of things about power of attorney. It ends upon death. So I get a lot of people in my office, hey, I was mom's power of attorney, she passed away, and now I need to get her assets from point A to point B. Well, power of attorney ends on death. So that's when hopefully you have a will, or hopefully you have some other documentation from mom other than that power of attorney. Power of attorney, really, I've I don't want to harp on the fact, but I really think everybody over the age of 18 needs one. I'll give you an example. A former client of mine called me. Her nephew was in the hospital at Kennestone. He had been in a motorcycle accident. He was mentally fine. Physically, I seem to remember his arms stretched out, and he was not able to move or to sign or to do anything, which was fine. He didn't really have any assets except the motorcycle he wrecked. The motorcycle he wrecked was an impound at a fee of $70 a day, something like that, $100 a day maybe. They would not let anybody remove it without the power of attorney. And so it was cheaper for them, he was gonna be in the hospital for weeks, cheaper for them to pay me to come to the hospital, do a power of attorney, so that the motorcycle could get out of the impound lot than it would be to pay that impound fee. So we did that, they got the motorcycle, he recovered, had another accident later. So hopefully he recovered from that too. Hopefully he's driving safer now. But that's just an example of where you would think, hey, I'm 18, I don't have any assets, I don't need a power of attorney. I really think everybody does. My daughter turned 18 this summer. I let her wait a day after her birthday, but the next day she signed her power of attorney. So the third, may talk a little bit more about those later, and we will have time for questions at the end, like Mike said. A lot of people don't want to ask public questions, but I will guarantee you, if you are wondering it, lots of other people in the room are wondering it too. And I'll be in the lobby if you, during the break, if there is something you want to ask without everybody hearing. Third document is the Georgia Advanced Directive for Healthcare. So it is pretty much a fill-in-the-blank form. I fill them out with a lot of clients, and we walk through them. There are kind of two sections to the form. One is, who do you want to make those decisions for you, those healthcare decisions? And then the second part of it is all kind of your choices on things. So do you want life support? Do you want to be buried or cremated? So things like that. It's a bit of a depressing form to fill out, but it's great so that if something happens to you, there's not any questions about what you would have wanted. I've had a few families in my office say they don't talk to their siblings anymore because disagreements about mom's health care at the end. And if mom had written it down, maybe they'd still be getting together at holidays, but they're not anymore. So those are the big three. We're going to talk about some documents that some people need, not everybody. So we're not going to spend a ton of time on these because these don't apply to a lot of people in the room, but big one is a living trust. We're going to talk in extensive detail about living trusts in a minute. So just kind of we'll put a pin in that. Special needs trusts are a second one. We're also going to spend a little bit of time on those later, but those are basically somebody with special needs does not need to inherit money directly for a lot of reasons. One, they can't handle it, and two, they lose a lot of government benefits if they have assets. So that's something to keep in mind too. We'll spend a little bit of time on those later. Life insurance trusts are common. They're not as common now as they used to be. They're a tool to hold life insurance to get it out of your estate. They're good for a number of reasons. We did them a lot more, though, when the estate taxes were a much bigger issue, and now they're not. There are other types of trusts. The trust I put there was a pet trust. Yes, people do trusts for their pets, and we're not talking about super wealthy people. I have a lot of very run-of-the-mill clients do trusts for their pets. And that's just because a lot of you have pets, I'm sure. Pets are very expensive. My dogs are very expensive. My friend's dog was in the hospital this week, $3,000 for pancreatitis. So they cost us a lot of money. So sometimes it's nice if you're going to give a pet to somebody to leave a little bit of money for the care of the pet. Power of attorney for care of minor child is used a lot with single parent situations. It's a nice way to give somebody the power to care for your child, or not even single parents. If you're on vacation, something like that, you're leaving the kids with the grandparents, they need to go to the doctor. This is a form that would let the grandparents hopefully not have much trouble taking them to the doctor. The last one there is a fairly new form in Georgia. We're not going to spend much time on it, but it's called a Psychiatric Advance Directive. So there's a kind of a gap in the law where people with psychiatric issues, when they're not having the issues, they're very clear on what they want if that happens. But then the moment the psychiatric issue comes up, suddenly everything's different. They don't want this now. They don't want you deciding for them. They don't want you giving them medication. So this is kind of a form to fill in the gaps where somebody that's doing well at one point can execute the form that would then become effective later if they're not doing so well. All right, we're going to change gears a little bit and talk about probate. So probate is what happens when somebody passes away. Probate has if you hear the word probate, it has a really bad reputation. Pretty much nobody has anything very nice to say about it. And in some states, that reputation is very deserved. So in some states, again, this process, somebody dies, they have assets in their name, we need to get them to somebody else, their kids, their spouse, whoever's written in the will. Some states, that terrible reputation is very deserved, because if you think about it, it's already at a bad time anyway. Somebody's passed, we've got things we need to do. Some states, the courts make it into a living hell. So it's huge fees, tons of time, tons of hassle, different burdens, things you have to do. The judge has to sign every step of the way. Georgia is set up, fortunately, to be a pretty simplified process. So it is not set up in Georgia to be a living hell. It is set up to be fairly easy. Do I have some living hell stories I can tell you in Georgia probate? Of course. But it's not designed to be hard. It's designed to be fairly easy. So what probate is proving a will. So if you have a will, if somebody passed away, you take it to the bank and say, hey, this will says that the money goes to me, give me the money. They have no way of knowing that's a valid will. They have no way of knowing anything about that will or about if that's even the legal will. So that's why we have a process in court where you actually give the will to the court, they look at it, they notify next of kin, and then they give you a piece of paper saying, yes, this is a will, you're executor, go do what the will says. So probate also involves supervising the distribution of assets to heirs and beneficiaries. So making sure that where the stuff is supposed to go, it actually goes. We also protect creditors in Georgia. We don't want somebody to be able to write a will saying everything goes to my two kids when they owe a ton of people a ton of money. We give creditors a chance to make claims against the estate. Probate generally occurs in the county where you pass away. So if you pass away, not where you pass away, where you're a resident of when you pass away. So if you're a resident of Cherokee County, you're going to do Cherokee County probate. Generally, it's the same process anywhere in Georgia, there's tiny variations depending on where you live. My final bullet point there at the bottom, it says it can be simple. Many wills actually don't need to be probated. We'll talk about that in a minute. If everything's owned jointly between mom and dad and every single asset, and there's really one of them passes away, likely you won't have to do anything in probate court because that's just automatic. And I do say it there, it can be simple, it can be a very simple process. Of course, it can be a nightmare too. One hiccup, and this is anybody that owns out-of-state real estate, perk your ears up now. Probate is done in every state where you own real estate. So I told you it's pretty easy in Georgia, and a lot of times we don't try to avoid it in Georgia. The complete opposite is true in Florida. Florida has a really bad reputation. It's very, very complicated, very expensive. You have to hire an attorney. They charge a lot of money. In Georgia, you don't have to hire an attorney. A lot of people do it themselves. So for people that own real estate in other states, that's great. Enjoy your beach house, but just don't leave it in your name only, generally speaking. You might want to get it in a trust, get it in an LLC, something like that. That's probably a little bit beyond this, but just keep in mind, if you have real estate in many states, you don't want to force your family to do that. All right, let's talk about ways that property can transfer when somebody passes away. Obviously, a will. You have assets in your name, you write a will. It says everything goes to John Doe. John Doe probates the will. He gets the piece of paper from the court, takes it to the bank, he gets the assets. We can also transfer property using a revocable living trust. We're going to spend, like I said earlier, we're going to spend a lot of time, or not a lot, a decent amount of time talking about those. Joint ownership of assets. So you have a joint bank account with your daughter and you pass away. That money becomes your daughter's. So I meet a lot of clients that have a joint account with one of the kids. They have several kids, one of the kids, and they say, is that okay? Well, there's pros and cons to that. The benefit of it is something happens to you, your daughter then or whoever's on the account immediately can access those funds. So it's just like a joint account. The joint account I have with my husband, he could be out there right now spending all the money in it as we speak. I don't know, but it's there available to him. Same thing with the joint account with your kid. They can go use those funds even when you pass away. So they can make it really easy to get money for those final expenses, funeral expenses, things like that. However, I do have a decent amount of clients who will like sell a house and they will move in with their daughter. And so they put all those home proceeds in their bank account. They don't want to put it in the stock market if they're older and worried about something happening, so they'll put it in the checking account with the daughter. Maybe daughter will share when they pass away, maybe not. So I usually mention, that's a big risk. If you're putting a huge chunk of your nest egg into an account with one kid and assuming they're going to share later, that's maybe they will, maybe they won't. I've had some clients that did not share later. So it can make it easier later on, like I said. So there's pros and cons. Another way is through beneficiary. So any retirement accounts pretty much all have beneficiaries. Those assets pass to who the beneficiary is. So those are going to avoid any kind of what the will says, any delay. Those assets go to whoever's listed as a beneficiary. So like I said, it's pretty common when one spouse passes, the other just gets everything automatically, either because it's joint, because they have beneficiaries, something like that. Let's talk about wills in Georgia. You have to be 14 to write a will in Georgia. I did a will for a 14-year-old once in Georgia who had more money than I will probably ever have, even when I'm retired, probably. So yeah, 14, you can write a will. Yeah, obviously have to be of sufficient mental capacity. One of my least favorite parts of my job is when a well-meaning kid usually, brings a parent into my office to do their will. And the parent can't answer any of my questions. The parent clearly is not of sound mind, and that's not fun for anybody. So have to be sufficient mental capacity to write it. The will must be written, no oral wills. The will must be signed and must have 2 witnesses. Witnesses should not be people who are going to be named in the will in any capacity. And they should be notarized. You can get by without notarizing them, but that just makes them harder to use later because you have to find a witness. And these witnesses usually don't know who they are. So it's better to have 2 witnesses and a notary. It makes it a little more difficult to sign because we have to have 3 people in the room with you when you sign, but that makes it legal and easy. Let's talk about some downsides of wills. Obviously, wills can be contested. So you don't like something your mom wrote in her will after she passes away, you can go to probate court. Probate court is a fairly friendly court. So I was telling you earlier that probate's pretty easy in Georgia. They try to make it easy for people to do these things. So one kind of downside of that is they also make it easier for people to contest wills. So that's a downside. Second kind of limitation of a will is that Georgia has something unique called years support. And that means when somebody passes away, their spouse or their minor kid can ask the court to give some stuff from their estate. And in most family situations, that's what you'd want to have happen anyway. You want your spouse or your minor kid to get stuff from your estate. Not always, though. You might have a blended family. You might be separated from your spouse. You might hate your spouse, whatever. That's not beneficial in those situations because you might write a will that says you get nothing and they can ask anyway and sometimes receive your stuff. And then kind of a third limitation, you still got to pay your debts. Unfortunately, you don't get out of your debts when you pass away. Student loans you usually get out of, but that's about it. So I told you earlier we were going to spend some time talking about revocable living trusts. So this is probably one of the things I get asked about the most. So I'm going to spend a fair amount of time talking about these. So revocable living trusts are a trust that you set up while you're alive. That's why it's called a living trust. And you put your assets into it while you're alive. So when I do one of these plans, we set up the trust, we deed the house into the trust. Often you put bank accounts in the trust, often investment accounts in the trust, kind of any assets that you have without beneficiaries. So IRAs typically just have beneficiaries in IRAs usually. The reason to do this is to avoid probate. That process I told you about earlier, when somebody passes away and they have assets in their name, and they pass away, they have assets in their name, you go through probate to get the assets from their name to where they're supposed to go. If these assets are in the name of the trust, then those assets don't involve probate. Probate's when somebody dies. If their assets held in the name of a trust doesn't die. So it's kind of a seamless way to pass the assets without involving probate court. This sounds really great, and I do a fair amount of trusts in a week, but it's my opinion not everybody needs them. So let's spend a little bit more time talking about those. The trusts obviously have to be funded while you're alive. You put your assets into it while you're alive. If you skip something, so maybe you meet with your attorney, you get everything in the name of this trust, and then a year later you open a bank account. And you think, oh, it's in my trust. My trust says it owns everything, and you just leave it in your name. Guess what? You pass away, you do probate just because of that bank account. So it's really not any good unless your assets get into it while you're alive. It's a great tool to use to avoid probate on out-of-state real estate. So I mentioned earlier, don't die with that Florida beach house in your name only, because then you're going to go through that hellish process in Florida that you don't want to do. So what you could have done was write a trust in Georgia, put the Florida house into it, and then you skip all of that. If you do a trust, you still need a will generally. That it basically says, if I forget to put something in my trust while I'm alive, put it in my trust when I pass away. It also appoints guardians if there's any minor children again. Good thing about trusts is they are not public. When you pass away, a will becomes public, so it's public record. So you can, and I'll use Cobb as an example because that's where I look at, that's the county I look up all the wills. Somebody passes away, you go on their website, anybody can get to that will that's been filed. What I will tell you is generally the will is doesn't have as much personal information as you might think. There's actually not much personal information. There's usually not lists of assets. There's usually not a ton of secrets in wills, but they are public. Trusts are private. Pretty much most celebrities that do any type of planning will do these trusts so that they do not become public. And that is a benefit of trusts. So you might be wondering, do you need a trust? Maybe, maybe not. I will tell you before I go over these bullet points that the times I do them in my practice are I do a lot for blended families. So blended families where husband has kids, wife has kids, they meet later. Maybe they don't want their assets all commingled. Maybe they earn this stuff separately and they want to make sure when they die it goes to their kids, not their spouse. Trust can be a pretty clean way to do that. I do them a lot for out-of-state real estate. Sometimes, a few times in my practice, I have done them for people with very interesting family situations. So maybe they're real clear, they want to give all their assets to their friend. Part of probate involves notifying next of kin. For 95% of people, that's pretty easy. If you've got a spouse or kids, you're done. They're somewhere in that list. When you don't have a spouse or kids, and you don't have siblings or parents alive, then it gets really tricky because then we're digging for cousins, aunts and uncles, things like that. So a few times I've done a trust simply because they have a really complicated family situation where they have 27 first cousins and that's their next of kin. We want to try to avoid finding all those people. Trust can be challenged like a will. It's a little harder to challenge a trust than a will, but if someone comes in my office and says, I want to do a trust and I don't want it to be challenged, I say, well, I could charge you $1,000 an hour. You could go to the best attorney there is, and there's no way to say something can't be challenged. If it's a legal document, it can be challenged. Trusts don't save estate taxes. Right now, we're in a pretty, like I said earlier, friendly estate tax environment, but trusts do not help with those. Pretty much the same. We're looking at the same tax situation as with a will. Trusts really don't save legal fees or administrative costs. You'll pay more on the front end to do it for sure. It's a lot more work for the attorney to do it. Could save a little hassle on the back end. It might not. So kind of my bottom line on trusts, like I said, I do several a week. I'm not antitrust, but I don't think everyone in the state of Georgia needs them. Some people do. Out-of-state real estate, occasionally a client with Alzheimer's or dementia can make it a little bit easier. Blended families or unique situations, like I said earlier. Let's talk about what an executor does. So this is when you're thinking about who you want to be your executor, kind of think about who in your family would be good at these things. So obviously an executor probates the will. They take that will that you've written to the probate court in the county where you live and file papers and get appointed as executor. They gather your assets together. They might hire an accountant. They might hire an attorney. They don't have to, but they often do to get a little bit more help. They'll pay any debts you've got. They'll deal with the IRS, which is no fun. They will distribute assets the way the will says, and they will give accountings to heirs, beneficiaries, and they do get paid for being an executor. So pretty common is to name, most of my clients name their spouse as executor unless there's some reason. Maybe if they're both in their late 80s, 90s, they know the spouse doesn't want to do it, they'll skip to a kid. If they're not married, they commonly name a kid for adult children. Kind of what I see after that's common. The younger clients sometimes will name parents, sometimes siblings. Sometimes people will name somebody outside the family. They say, hey, I know my family, I know how they fight. I'd rather just have my friend give the money to them so then there's no question. So it's a very fact-driven decision. You don't want to name a procrastinator. You don't want to name somebody that does not communicate well with others. Often when things go awry after somebody passes away, it's not because the executor is doing anything wrong. It's not because any wrongdoing has occurred whatsoever. It's because the executor is not communicating. And so, fear and mistrust starts to develop when mom died 6 months ago and I haven't heard anything, when the executor could have sent an email weekly or monthly and say, this is where we're at, and avoided all of this family drama at Thanksgiving. So think about somebody who can communicate well. Like I said, no procrastinator, somebody who's good with paperwork, somebody who can get things done. Generally, type A personalities are great executors. So people always say, why do I need a will? What happens if I die without a will? This is the top stat I found several years ago. I've read that from several places. I don't know if that's still true, but I have read that 70% of the population dies without a will. I don't find that too hard to believe because the people that come to my office that haven't done wills yet can sometimes be surprising. I've done wills for about 5 90-year-olds who said it was their first will. And all 5 of those people, there were 5 different people, they all said, I got to thinking after I had my car accident last year, or I got to thinking when I had surgery scheduled, and I always want to say, but obviously I don't, you're 90, don't It takes a car accident or a scheduled surgery to get you to do your will, but maybe I guess they're optimistic. I've also read that about 50% of people die with almost no assets, so that might be the reason they don't write a will. If you die without a will, the court decides who your administrator is. An administrator is a person appointed by the court. It's not an executor because you haven't done a will to name an executor. They're called an administrator. Often the worst part is the court can require the administrator to do a lot of things that they wouldn't have to do had you had a will. So if you write a will with any attorney that's ever done a will before, they will know to use certain words in the will that say you don't have to do this, you don't have to do that, just to kind of make that process easier. Obviously, if you don't write that, if you don't do a will, you can't waive those requirements. So it makes it a little harder. If there is not a will, any assets that pass through that estate, and remember, we're not talking about joint accounts, those pass automatically. We're talking about things that were in that person's name only that did not have a beneficiary. The spouse and children actually inherit equally. A lot of people would assume everything goes to the spouse and the kids. That is not the case because of blended families. We don't want a stepmom getting everything when really the kids, the parent probably would have wanted the kids to get something. The spouse gets no less than 1/3 of the estate though. So if there's a ton of kids, spouse gets 1/3, the kids share 2/3. If there's one kid and one spouse, it's 50-50. If there are no spouse and kids, it goes to your parents. If they're alive, then siblings. Parents first, then siblings, then we go down the list of nieces and nephews and things like that. The further down that list we get of people who are inheriting from you, we call them laughing heirs because they did not know you, They have no relationship with you. They are very happy that they get this surprise inheritance they weren't expecting. Obviously, if you die without a will, you cannot write anything about friends. You cannot write anything about charities. Even if you don't want money to go to friends or charities, you might not like those next of kin that the assets go to if you die without a will. So just kind of a good reason to write a will. If you do pass away without a will, you cannot set up trusts. So for people with minors, that's pretty a bad result, because people with minor children, those children are going to inherit those assets, but it's in a complicated manner. The court holds the money for the children until they're 18, and then distributes it all to them when they're 18, which is a terrible idea for most 18-year-olds. Personally, I was a nerdy, responsible 18-year-old, but if I had gotten any kind of lump sum, I guarantee you it would not be here today. I would not have spent it in a good manner. So that's bad, but you didn't write a will, so you can't say hold the money until they're 25 or 30 or whatever. Obviously, if you don't do a will and you have a special needs kid or grandkid or something like that, you can't really address that. And so I've had a couple sad situations where some mom or dad took care of their special needs kid their whole life, didn't write a will for some reason, or just wasn't thinking about the special needs when they wrote the will. And then the kid came into an inheritance when they died, and suddenly they lose their SSI, they lose their Medicaid, all this stuff, till that money's gone, and they have to reapply. So that's a group that definitely needs to do some type of planning. Anybody with special needs, loved ones. Let's see. What if you become incapacitated and you don't have a power of attorney or health care directive? So incapacitated, maybe dementia, Alzheimer's, although usually you have a little time to plan from when you find out that something like that's an issue. Or maybe it's an accident, maybe it's something sudden. Ideally, if you have those forms, power of attorney, healthcare directive, you've got at least something in place that will help people step in, pay your bills, do things that they need to do. If you don't have those, and I've actually had a couple calls in the past 2 weeks of suddenly mom, we weren't expecting anything to happen to mom. She said she had done some planning, but we can't find any documentation, and now XYZ's happened. How can I pay for this facility she's got to go to? How can I sell her house? The answer is not a great answer. It's getting a guardian or conservator appointed. And that's also done in Georgia, it's done in probate court. It means, if you've ever heard the phrase on a television show or somebody talking about having somebody declared incapacitated, that's basically what that is. You are approaching a court, you're saying, court, this person can't handle their affairs. Can you please allow me to do that? And so there is a way to do that. So if mom is in that facility and we have to sell the house, we have to do all these things for her, we can get it done. It is extremely expensive. It is very lengthy, and it's a great time for families to fight. It's not a great alternative to doing a power of attorney or healthcare directive. Power of attorney, healthcare directive are hundreds of dollars. Guardianships and conservatorships are thousands of dollars. And then once you get them, then there are a ton of annual reporting requirements and things like that to the court, which are just not ideal. So, but at least there is a way to be able to do that. Let's talk for a minute about long-term care planning. So we're talking about nursing homes, Medicaid, things like that. I don't do a lot of extensive long-term care planning, but I know the basics, so I can tell you the basics. Medicaid will pay for a nursing home, but you've basically got to be broke. You've got to have very low income, very low assets, and Medicaid will pay for the nursing home. Medicaid does not want to encourage people to find out they need to go in the nursing home and suddenly move all the assets to the kids so that Medicaid will pay. They don't want to do that. So there's a period called look-back period. It's 5 years. So they look at all transfers made 5 years before the nursing home to make sure that you're not getting mom broke the day before you go into the nursing home. And if you have transferred a bunch of assets, then there's going to be a penalty that's going to apply. Some people get some VA benefits. If you've served in the military, the VA has some nursing home benefits Those asset and income limitations are a little different. I don't know a lot about that, but I do know that that's available. Some people purchase long-term care insurance. I don't know if anybody in this room has ever priced long-term care insurance. It's very expensive, but the longer that this product is out there, there's a lot more options now, so it may be something to look at. It's couples can get it where either spouse can use it for a certain amount of months. You can put a certain amount of dollars per month if you have to go to a nursing home, something like that. So that might be worth purchasing for some people. Some people it's not affordable or it doesn't make sense. Some people can self-insure. It's just a lot of it depends on your situation. Let's talk about planning for incapacity. We kind of already talked about that, but basically 2 basic forms: power of attorney, healthcare directive. I mentioned there incapacity can occur anytime to anybody at any age. I gave you that example earlier of the guy in the motorcycle accident. He certainly was, when he was driving down whatever road he was on, 75, and got hit by that car, he definitely was not thinking about incapacity at that moment, but good thing he was able to get that power of attorney and things worked out for him. Generally, just those 2 forms are a very good start for planning for incapacity. I will tell you, so when you do a power of attorney, it's a general document. It says, hey, I give my kid, I give my spouse, whoever, the power to do these financial things for me. Banks, so let's imagine that something happens to mom and a kid goes to the bank and tries to use that power of attorney. You can imagine the bank is not usually thrilled to see strangers coming in with wanting to access somebody's account, some document that they've never seen. So it takes a little bit of time. It's not automatic. They want legal to look over it. They want to make sure that their I's are dotted and their T's are crossed. So I also tell people, if you have a bank that you have a good relationship with, you have a decent amount of money in there, they all have their own internal forms. I shouldn't say they all do, but I think most of them do. An internal power of attorney. So you could go to the bank and say, hey bank, I know that if something happens to me, I want my spouse or my kid to be able to access my money. I want to fill out your form. And that could be a good thing to do just because they're going to put the stamp of approval on it. There's not going to be this big waiting period. It just kind of simplifies the process. Whereas the general one, they want to spend some time scrutinizing it. Sometimes living trusts can help with incapacity. We talked a bit about those living trusts earlier. Those are tools that hold your assets. It can be a little easier for somebody to manage something that's in a trust versus trying to use a power of attorney, but that's kind of beyond this discussion. If someone, I mentioned that 3rd bullet point earlier, no incapacitation planning, then you're gonna have to seek a guardianship, conservatorship. Expensive, takes a long time, and that person then doesn't get to choose who handles their affairs. The court appoints who handles their affairs, and often it's not the person, the court does not appoint the person that the incapacitated person would have picked. So anyway. Enough about that. I guess I've nagged you enough about power of attorney. Estate and gift tax. We're not going to spend much time on this. You are all retired teachers. I don't think we probably pay our teachers enough to get up to $13 million, which even if you're extremely frugal, in 2023 you have to have almost $13 million to pay estate taxes. They're going to lower that in a couple years. It is still going to be to 7. I don't think Georgia pays its teachers enough to get to 7 million, but just kind of keep that in mind. If one of you gets a large inheritance, you have a side job where you earn millions of dollars, then you need to think about some estate tax planning. There are charitable, if you make charitable gifts, that will come off the top. That's probably enough about that. Let's talk about gifts. Gifts and estate planning. I get asked all the time, should I be giving this stuff to my kids now? Should I be writing checks to my kids every year? Well, that really depends on you. So if there's money that you need to live on, then no, don't give it to your kids while you're alive. I had a distant family member who sold a house and decided she was going to write checks to her kids. And she did that. And about 5 years later, she came asking for the money back. And that was very awkward because some of them had put it as a down payment on a house, had spent it. I don't think any of them blew it, but it certainly wasn't just sitting in an account ready to give to her. So always keep that in mind. We don't know how long we're gonna live. People are living older these days. So if you need it, no. Gifts are beneficial if you need to get stuff out of your estate. So a couple reasons you might need to do that. One is the estate tax, which I mentioned most teachers are probably not going to pay estate taxes. Or really most people in general aren't going to pay estate taxes because it's so high right now. Maybe if you need to go into a nursing home or something like that, gifting can be a good way to get that money out of your estate. You can give currently $15,000 a year to any person that you want, and there's no gift tax. So you write a check to them, the IRS doesn't care, you don't have to tell anybody. You can give over that, but you have to let the IRS know. All right, I get asked a lot, what if I have a smaller estate? I have a lot of people, or I've had people tell me, I don't have an estate to plan. You would be surprised. I have done wills. For one will I did, this lady basically only had a double wide, and she also hated her husband. So she was willing to pay an attorney to write a will that said the double wide goes to somebody other than the husband. And she was happy, and I was happy. And so that's an example of somebody that didn't have a lot of assets, but it was pretty beneficial to do a will. So those three basic documents, pretty much, even if you think I don't have a situation that requires that, you'd be surprised. That example earlier, the motorcycle guy, he didn't think he needed power of attorney, and he did. Wills are pretty important, like I said, for smaller estates because, that double wide example, she knew who she wanted her executor to be. If she had not written a will, probably would have been the husband. She knew where she wanted her property to go, not to the husband. So that was important. And kind of the biggest thing, it makes that process a lot easier because you can write requirements in there to make it a lot easier. So, all right, let's talk about special needs children and grandchildren. So if anybody in this room has special needs children particularly, it's really important to do some type of planning. Doesn't have to be expensive planning, but needs to be not doing nothing for sure. Grandchildren as well, but especially children. So for special needs children, and this could be adult children as well, you set up a special needs trust. And I told you earlier, if a special needs person gets any significant, even not even significant, a few $1,000s of an inheritance, they're kicked off Medicaid, kicked off SSI because they have their own assets then. So you can easily avoid that by putting some special language in your will or putting special language in a trust. It's a good idea to do a letter of intent. That's just instructions. Hey, special needs kids have a lot of instructions that go along with their care, a lot of doctors, a lot of therapists, a lot of routines that they need to do. And if nobody else in the family knows any of that, then that's a pretty steep learning curve. So that's a good thing to do. It's also nice to set up plans for guardians, caregivers, things like that. For grandchildren, so grandchildren, if you want to make gifts to special needs grandchildren, you can do that, but using this special technique with a special needs trust, because again, giving them money directly is not ideal. What you do not do, you do not use their name in the will directly. You do not say, I give a quarter of my estate to my special needs kid without saying anything else. You also don't put them as a beneficiary directly or the owner of an asset. I had a really sweet lady once, set up a custodial account for her granddaughter with Down syndrome, $2,000. Very well-meaning, but that even $2,000 can disqualify you from some benefits. So I don't remember what we did about that, but we did something so that it didn't hurt her later. All right, this is a question I get all the time, and there is not a good answer to it. It's going to depend on you. What do I tell my family about my affairs before I pass away? It depends on your family. At a minimum, here's the minimum. Tell them I have done some planning. My documents are located in my XYZ, my safe, my file cabinet, whatever. You are named as my executor. You are named to make healthcare decisions. I would not be pleased if somebody called me and said, guess what? You're named as your great aunt so-and-so's healthcare agent, and she's in the hospital. Like, I would like to know that in advance so I could have a talk with her to see what she wanted. So it'd be good to know where the documents are at. I was in New Orleans once at Christmas, and I got a call from a medical center, and it said it on my phone, so I answered it. We found so-and-so, he has a note. We found him in his home. He has a note on his wrist to call Sarah White if something happens. And fortunately, it was Christmas Eve, but I answered the phone, fortunately, and I was able to send a document, but it would have been better for the people that were in his life to have a note to say, call my kid or call somebody, so that somebody else had known other than me. At a minimum, tell them where the documents are, tell them that they are named to do particular things, tell them, the healthcare people in particular, tell them your wishes about life support, burial or cremation, things like that. Because that, like I mentioned earlier, a lot of families really get divided about how so-and-so did mom's care after she died, and that's not what she would have wanted. And so having a conversation and giving a document that says that's very helpful. With your documents, you should leave something called a memo to your loved ones. That is a form. That's not really a legal name of any form, but that's a form I use. That's the name I have. It's like a 10-page document that says, it's a place where you can write things they need to know, where your assets are, what your passwords are, things like that. Even if you do planning, so you do all these documents that I'm telling you to do, they're generally pretty generic and don't have a lot of specific instructions. You can get a copy from me. If you email me, I'm happy to send you a copy, and I do not add you to any mailing list or anything like that. I will send you the form that I use, and that's just, like I said, just a kind of a fill-in-the-blank form. Some people go to the other extreme, so some people tell the very minimum to their family members. Some people tell everything to their family. Some of my clients say, we're sitting around with the kids at Thanksgiving, I'm showing them all these papers, and we're going to talk about who's doing what. And that's fine for some families. It just really depends on the situation. A lot of older generations do not like sharing info like that. But it is good to know where the documents are and kind of the basic, where the assets are, things like that. Let's talk about some mistakes I see very commonly. Number one, no planning whatsoever. So we've already kind of talked about the downsides of what happens if there's no planning at all. So if you pass away with no planning, the assets go where the state of Georgia tells them to, tells where they go. Sometimes that's not the end of the world, but often that's not the people who you'd want your assets to go to. It's often a really big deal, incapacitation, if you haven't done any planning. Second one, not updating the plan when it's done if something major changes in your life, a divorce, somebody passing away, you move to another state. So you can do a great plan for the situation that exists at that time, but then if something major happens and you don't change, then that's a problem. Not changing beneficiaries. Beneficiaries trump what's written in your documents. So I had a client once, her stepmother was named as beneficiary of her dad's $250,000 life insurance policy. They divorced. He went nuts and passed away a year later. And then guess what happened? The stepmom got the life insurance because he did not change the beneficiary. They lived in a small town. Mom bought a new car, drove it all over town. Stepmom bought a new car, drove it all over town. There really wasn't anything she could do. So keep those beneficiaries updated. Next one, drafting a living trust, but not putting your assets into it. You paid a lot of money then for a document that really does not help you very much at all. Poorly drafted documents. So here's where I get my little dig into LegalZoom. So most lawyers hate LegalZoom, of course, it's a competitor to me. I don't really have a lot of negative things to say about LegalZoom. They can make some decent documents. I would say the downsides are if there's any slight variation from the normal, then it's pretty hard to use them. Also, a lot of people will do the LegalZoom wills and then never print them out, sign it, notarize it. I hear that all the time. So. That could be a limitation. Not properly titling your assets. The example would be that $250,000 account I mentioned earlier, where mom sold her house, put the money in the account with the daughter, and that was a joint account. Maybe that's not what mom meant. Maybe mom wanted some of that money to pass to the other kids. Probably the most common improperly titled asset I see is a house that's owned by husband and wife. So the husband's on the deed, the wife's on the deed, but it says nothing beyond that. So Years ago, deeds used to say John Doe and Jane Doe, period. And when John Doe dies, his half of the house does not automatically go to Jane. There's something you got to do in court to get it. It's not the end of the world, but it can be easily changed if there's a deed that says joint with right of survivorship. So the newer deeds, when I say newer, even like 20 years old could be a newer deed. Most of the newer deeds say that when it's a husband and wife. Those older deeds, we sometimes run into issues because they don't say anything about survivorship. Not planning for long-term care can be a problem. Not signing and notarizing the documents properly. So we need 2 witnesses and a notary on wills. That sounds pretty easy. That's harder than you think sometimes. Not letting anybody know you've done the will, or telling them you've done it and not putting it in an available location where anybody would look. Had a client once, her mom left the will under the TV, the big TV, like the old school TV. She thought, I guess she thought that was a safe place. Those TVs were so big and heavy that it was secure. They didn't find it till after the house was sold, after everything had already happened. So let people know where these documents are. Let loved ones know about your financial affairs a little bit. Like I said, a lot of people don't want to share that with their kids, and I understand that, but you could leave written instructions with the documents to tell them about that. And then not planning to avoid estate taxes. Again, we're in a good estate tax environment, so that's not as big of an issue. Back in the back, and somebody's going to come around with a microphone, I think, but I should be able to hear you. There we go.
Thanks. So you mentioned funding the living trust while you're alive.
Yes.
But you made a statement about in your will designating something to go to the trust, which sounded like that could happen after the fact.
Yes, but so her question was, I said that you need to put assets into the trust, fund it while you're alive, but you could also write a will that says it gets funded after you die. Yes, pretty much most people that do a trust will do a will called a pour-over will, and it says after I die, put any assets I forgot to put in my trust. Every time I do a pour-over will, I tell a client the goal is to not use this, because part of using it is probating it, and that's the process that you're trying to avoid. So you can get assets into it, but you got to probate it, which is, again, part of the reason of doing it is to avoid probate. Does that make sense?
What was that term of the will you said?
A pour-over will. So pour, like pour from a pitcher, pour into my trust. Sure. Any other questions?
You were talking about special needs children, but what if your child is not special needs in terms of
Medicare and things of that nature, but doesn't make the best decisions?
So that's a very good question. I'm actually surprised I'm surprised I did not mention that earlier. So that's a very good question. She said, what if we have a kid who's not special needs, but they are not great with money, don't make good financial decisions? That is also done with a trust, but it's just not a trust with the special needs language in it. So it doesn't say rules about what you can spend the money on. It says, hey person, you're holding this money for my kid, you're doling it out to them at these ages or for these things, but the kid doesn't get their hands on it. Those are very, very common. And I do them weekly for minor children, of course. We'll say, like, hold it till they're 25 or 30. Or for kids that just don't make great decisions, we'll do that. There's also, which I didn't mention earlier, there are a lot of my clients have kids on drugs, unfortunately, or who are addicted to alcohol, something like that. There are special trusts you do for that too. It basically has a lot of really tight lockdown language that says spend the money on the rehab, spend the money on these things supporting them, but they are not to get their hands on it, and they got to test clean, and they got to do this and that. So that was a good point. I should have mentioned that earlier. Any other questions? Yes.
Ma'am, I've got a mic for you.
Sorry.
When you were talking about mistakes, so if I look at how our house is titled and don't see joint with right of survivorship, what do I do?
So that's a good question. She asked if she looks at the deed, and the deeds are available online. They're just sometimes hard to get to depending on your county, but they're free online. If she looks at the deed with her and her husband and it does not say joint with right of survivorship, what does she do? Well, if you know you're going to sell it in a year or two, just maybe you don't fix it. But if it's your forever home, you know, hey, when I pass, I want this home to go to him automatically. It's a matter of drafting a new deed that you both sign to put that language on there. It's usually the older deeds that we have the problem with, and I don't know enough about real estate law to know what changed, why we went away from not saying survivorship to saying survivorship, but I'm kind of glad that we said that because that we changed that, because most people assume, hey, we're both on the deed, it goes to him automatically, and that's just not the case. So just doing a new deed to add that language.
My question is around trusts.
Oh.
If you already have a revocable trust, should you go to your bank, or obviously not your retirement accounts, but savings, checking, and so forth, to change the beneficiary to that trust?
That's a very good question. Yes, he said if you already have a revocable trust, should you go to the bank and change the beneficiary to be the trust? Yes, that is a great way to do it. There's a few ways to do it. One is actually putting that account in the name of the trust. Kind of the downside of that is they usually make you open a new account, which means all those bill pay, all those things that come out automatically, you start from scratch, and that's a pain. An easy way is to make the trust the beneficiary, yes. Yes?
Question about if you are the recipient of money from a family member. Is there a point with him you report that purpose?
So he asked if he gets an inheritance from a family member, does he report that for tax purposes? No. Because if it was a huge inheritance, so we're talking the 13 million federal, or a lot of states have a much lower threshold, but that money should be paid off the top by the estate, any kind of estate taxes owed, and what you get is just yours normally. The rules are a little different for IRAs and retirement accounts, but any cash, yes, it's just yours.
If you own a property here in Georgia and you own another property in a different state, do you have to put the trust for both states, or one state will cover both?
Once she asked if you own a property in Georgia and a property in another state, do you have to do two trusts? No. Generally, you can do one trust, and that trust holds multiple properties in multiple states.
Okay, I have two questions. The first one is about the deed. How do you check that to make sure that it's correct with the joint right of survivorship?
So that's a good question. She wants to check her deed to make sure it says joint with right of survivorship. So after the closing, they send you the deed. So they mailed it to you. Now it's a couple weeks after the closing, so people usually get it in the mail. Maybe it makes it in the packet of the closing papers, maybe it doesn't. But you've got it. So if you can find it, great, and look at it. If you can't find it.
No, we can't. We bought our house in 1998. So okay. Yeah, I was like, oh, I have no idea.
If you can't find it, then you can go to the county where you live, so the courthouse in the county where you live, and they have it. So you can look that way. You can try online. It depends on your county. And the easiest county to look up that I work in is Cobb. They're just really easy to find, but they're available online.
Okay, now my other question might sound dumb, but so I see on the little thing that our TRS benefits, that supersedes a will. Do we have to put, because we have a living trust right now, do we have to put when I retire, do I have to put that in the trust or no? Okay.
She asked about putting her TRS benefits in a trust. No. That TRS tells where those assets go.
Just a quick question about family members living overseas. Does that complicate wills?
Yes. So he asked about family members living overseas, and does that complicate it? From your point of view, no. You can write a will that says my money goes to my son in Germany. That's fine. You can do that. And so it's really easy from your point of view. Where it gets tricky, a lot of my clients are immigrant families with they may have a cousin here and everybody else lives in India. And so then it's tricky to find people to actually name to do some of this stuff. So you really don't want an out-of-country executor. You don't want an out-of-country person making healthcare decisions for you. So that's one area it gets tricky. Second is those countries often have rules about getting money into that country and the country taking a part of it or holding it. And so it's easy for you. It's maybe not so easy for them.
So in our original will, our kids they're in a trust before we die, until they're 30. So when they turn 30, do we have to do another will?
So that's a really good question. He said his will says that the assets are held in trust till the kids are 30. When they're 30, does he have to do a new will? The answer, there's a yes and a no. No, because if they're over 30 when you pass, then that provision's pretty much just disregarded. So you just look past it and you say you're over 30, okay, you get your money, we don't put it in trust. But the reason you might want to think about it is because normally when you write those wills for kids under 30, there's a lot of other things those wills say, like who the executor is, who the trustee is. And it's not going to be the kids, it's going to be like your brother who's probably the same age or close in age to you. And so it may be a good idea to update to maybe actually name the kids to do that kind of stuff, but you don't have to update just to remove that 30-year-old language, if that makes sense. And there was a lady in a purple shirt that wanted to ask, yes.
So my husband and I just did a will. My understanding, though, if we own real property, the will does not prevent the assets going through probate. Is that correct?
Correct.
Okay. So do you recommend then that we put a child or children on title of the house?
No.
Okay. To avoid probate?
No. So I should have mentioned that earlier too. You're thinking of all kinds of things that I could tell you. No. So I get asked that probably once a week. Should I put my kids on my house title? Some states will let you write a deed that says, when I die, give my house to so-and-so. And that's fine. Georgia does not recognize those types of deeds. So two choices if you want to avoid probate on the house when you die. Choice one, you could put them on the deed, but keep in mind two major reasons not to. One is tax issues for them. The bigger reason, almost the bigger reason not to, is let's say they get divorced, they have a DUI and hit somebody with their car, they file bankruptcy. They're an owner of that house. And that's a huge problem for you potentially. The creditor doesn't care that you just put them on there to avoid probate. You could put your house in a trust to avoid probate, but like I said, it's going to depend on your situation. Probate's not something in Georgia we always have to try to avoid. Sometimes yes, often no.
You mentioned having your spouse or loved ones on titles or bank accounts. What's your recommendation on automobiles or boats, things like that, as far as putting other people's names on them?
So that's a good question. He's asking about putting other people's names on automobiles and boats and things like that. Georgia makes it very easy to transfer those assets when somebody dies, and that's usually done at the tag office, just with a death certificate. I had a client do it yesterday, actually, no problem at all. So if you're putting them on there just to avoid that, probably not. Personally, I'm not crazy about being on other people's car titles myself because I don't want I want to minimize my liability as much as possible, and it's really easy to deal with. There's a question back there and then one right here.
I may have said this already, but does the will override the deed? In other words, if the deed is, I'm on somebody's deed, I have a share of the house, then the will says something else, which is...
So that's a good question. He asked, what trumps, the will or the deed? If the deed says rights of survivorship with John and Jane has written a will that says nothing to John, too bad. It says rights of survivorship, that house goes automatically. It doesn't matter what the will says. If they are co-owners, so 2 people own a half or 3 people own thirds of a house, and it doesn't say anything like that, then the will tell where their share goes when they pass away. Oh, right there.
You mentioned a while back about the 5 years look-back period. What would you suggest is the process if we do want to transfer our parents' assets as they are aging?
So that's a good question. She asked about parents who are aging, 5-year look backs, getting stuff out of their names in case they need to go into a nursing home. I don't have great answers on that because there's not a one-size-fits-all answer. Generally, the best way to do it is to visit an attorney that does that type of planning who will put their assets in a trust. And then that way those assets are still there for your parents, but they're protected after that 5 years passes. Downside to that, those attorneys are very expensive, and I don't begrudge them that because it's a ton of work. I don't do that type of planning. It's a ton of work. It's very complicated. It's a lot of liability if they mess something up. So that's expensive, but nursing homes are also very expensive. So it's kind of a balancing act by looking at that likelihood they'll be in the nursing home, likelihood they can't pay for it for any length of time, and then deciding, is it worth paying to the attorney to do these documents to protect them, or is it not worth that? So yeah.